Good afternoon, everyone. Our webinar will officially begin in 5 minutes. In order to have a smooth and efficient program, please note the following house rules presented on the screen. Thank you. Pleasant morning, afternoon, evening, wherever you are. Welcome to our webinar titled China's Incursion in the Julian Felipe Reef, Legal and Security Aspects. This event is organized by the Miriam College Department of International Studies in partnership with the Philippine Strategic Forum. To formally open our program for today, may I call on the President of Miriam College, former Ambassador Laura Kiambao del Rosario, to give us the welcoming remarks. Ma'am?
Okay, thanks a lot, Jonah. I'm sorry I had to search for the mic. Okay, thank you very much, and good afternoon to everybody. And I wish to welcome all of you to this webinar of the International Studies Department of Miriam College and also of the Philippine Strategic Forum. I'm especially heartened by the presence of our students and happy to welcome colleagues in the academe and in security issues. I hope you'll forgive me if I go beyond the welcome remarks to introduce the topic within the context of recent political events in our history for the sake of our students or any student who may have developed an interest in the UN Convention on the Law of the Sea, the South China Sea, and the West Philippine Sea issues, and in all things maritime. The SES has been a major issue of concern for us who work in foreign relations. I was a mid-career officer when the Philippine Senate decided to abrogate the extension of the military bases agreement in 1991 that the DFA and the DND had negotiated with the US government. The abrogation led to the closure of the US base in Subic in November 1992, while Clark had to close down due to the eruption of Mount Pinatubo that year. A few months before the closure of Subic in November 1992, the Philippines hosted the ASEAN Summit, and the government pushed for the issuance of the 1992 Manila Declaration on the South China Sea, anticipating possible developments that might be detrimental to our national interests and sovereignty. The declaration underlined the need for various forums and forms of cooperation and a code of conduct on the South China Sea. 3 years later, in 1995, an installation put up by the Chinese purportedly for their fishermen was discovered at the Panganiban Reef, or internationally known as Mischief Reef. Our government wanted to go deeper into discussion on this development, but the floor contemplation case erupted in the media, and the Panganiban Reef news was overshadowed by the rallies held for contemplation. To make matters worse, the Secretary of Foreign Affairs at that time, Bobby Romulo, had to resign because of the OFW case. It was a very frustrating time for us involved in political and economic affairs, although we did not diminish the importance of the OFW concerns. In retrospect, I started to understand later on why the contemplation case had the public's interest more than the Panganiban Reef, because the contemplation case was an issue that we call malapit sa bituka, a case of survival for the working class. And if everybody had noticed, it was our relationship with Singapore, not China, that went under strain. Filipinos burned the Singaporean flag, in public places. 17 years later, the Scarborough Shoal incident happened, and this time the public was very much interested. It is now 2012. The perceived restrictions against our fishermen fishing in their traditional fishing grounds was an issue called malapit sa bituka. Relations with China this time were the ones that went under pressure, and the Philippine government saw it fit to seek arbitration at the Permanent Court of Arbitration in The Hague, which handed a ruling predominantly in our favor. So here we are now with the Julian Felipe Reef issue, and I'm glad that Dr. J. Batongbacal is here to discuss the ramifications of the situation. Jay and I crossed paths when I asked him in 2011, or 10 years ago, to deliver one of the lectures in the 6-lecture series on the UN Convention on the Law of the Sea and Maritime Issues at the Foreign Service Institute where I was then director. It was meant primarily for the newly commissioned Foreign Service officers, but I took advantage of Jay's presence to invite the other officers and staff in the home office, as we call our headquarters along Rojas Boulevard. It became a standing room only lecture series, and I'm sure that today's lecture will be more interesting than it was then when the Scarborough Shoal and the arbitration had not yet happened. So I thank you all for being here with us, and I want to welcome you once again. And to you, Jay, maraming salamat uli. Good afternoon.
Thank you very much, Ambassador Del Rosario, for your warm welcome and for providing us the context of today's topic. Now, to introduce our resource speaker, please welcome the chair of the Miriam College International Studies Department, Dr. Melanie Reyes.
Thank you, Ms. Chona. So good afternoon to all our guests and welcome again to Miriam College. It is my pleasure to introduce to you our guest speaker for this afternoon session, none other than Professor J. Batongbacal. Professor J is the director of the UP Institute for Maritime Affairs and Law of the Sea. He teaches courses on property, obligations and contracts, and law of the sea and natural resources. He obtained his Bachelor of Laws from the UP College of Law and master's degree in marine management and doctorate in the science of law from Dalhousie University in Canada. His graduate degrees were acquired under scholarship grants from the Canadian International Development Agency and the prestigious Pierre Elliott Trudeau Foundation, respectively. Professor J was a member of the technical team that prepared and defended the Philippines' claim to a continental shelf beyond 200 nautical miles in the Benham Rice region, made in a submission filed with the Commission on the Limits of the Continental Shelf pursuant to the provisions of Article 76 of the Law of the Sea Convention. The CLCS recognized Philippine jurisdiction over the Benham Rice region in April 2012. So without further ado, let us all welcome Professor J. Batongbacal.
Hello. Hi. Good afternoon, everyone. Thank you, Ambassador Del Rosario, for the introduction, and also to Mel on this. I have been invited to give a talk on basically what contemporary issues, what current issues that are still actually developing. No? This is not yet over in a sense, and just this week, we've seen more developments take place, especially the announcement of the National Security Advisor that the government has decided to send vessels into the West Philippine Sea, as well as encouraging fishermen to continue to fish in the West Philippine Sea. These are all very prominent, very controversial, and I'm sure people are very much aware of various aspects of it. But we must also keep in mind that this is just the latest episode, shall we say, in this long-standing and evolving disputes between the Philippines and China. Now, prior to this talk, I was sent a list of questions that were provided by the participants when they registered, and it's really quite a lot. I think nearly 100 questions. And I have scanned them, and I will try in my presentation to address as much of it as I can, in the hopes that this will provide some clarity into what is admittedly a rather complicated legal, political, and diplomatic situation. Okay, so let me begin by first sharing my screen. Oh, could I have the screen there? Okay, here we go. I have tried to keep the slides to a minimum because I tend to really go off track whenever I have a bunch of slides. It's sometimes hard to keep control of what you want to talk about because there really is so much to talk about whenever you start discussions about the West Philippine Sea or any recent event and controversy. So let me just check. I have the opening slide now. Did it move? Is there a new slide? Can you see the next slide? Basically a subtitle, The West Philippine Sea and the Victory in the South China Sea Arbitration.
Yes, you can see it.
Okay, okay. I need to make sure of that because it's always been happening to me that I go off and I thought that the slide is moving, but actually it isn't. Anyway, so let us begin first with a kind of leveling off on the situation. As you know, the Philippines and China have a long-standing dispute in the South China Sea and West Philippine Sea. Okay, this dispute is complicated because it comprises at least two major categories. You have the territorial disputes, meaning disputes over the sovereignty of islands and rocks, well, what are now referred to as high tide elevations, basically, in the South China Sea. Okay. And the maritime disputes, the second category is the maritime disputes. These are disputes over jurisdictions in the sea beyond those islands and rocks. Okay, so this mixture often leads to a lot of confusion. Okay, especially if you're an ordinary citizen who is not familiar with the legal and geographical complexities of the region. Okay, now the disputes between the Philippines and China have been basically ongoing since the late 1960s when the Philippines occupied the Calayan Island Group. Okay. Prior to that, there were some, shall we say, preliminary movements, but these did not result in our occupation of these islands. No? And the taking of taking control of these islands was basically, shall we say, consolidated, no? When the Philippines issued PD 1596, no? Declaring or creating the municipality of the Calayan Islands and placing it under the jurisdiction of Palawan. No? This action, no, shall we say, is the first formal expression of the Philippines because it's contained in a presidential decree. And since that time, for a while, the disputes were basically under the radar for most of our people. Because if there were any incidents, say fishermen being arrested, detained, or things like that, those types of incidents were relatively isolated and took place in proximity of those various islands and rocks. Okay, this took place, kept on until around the 1990s. Why? Because by the 1990s, some things began to change. While the various countries, no, not just the Philippines and China, but also Vietnam and Malaysia, while they had established outposts on the various islands and rocks that are present there, the fishing activities did not really pose a problem for most of these countries. Okay, this is the 1970s. And in the 1970s, prior to the negotiation and conclusion of UNCLOS, basically there were no EEZs yet, no? Or it was not yet fully established international law. So everyone was basically able to fish freely within the entire South China Sea. Okay, but after the 1970s, you had a combination of the expansion of fishing activities of the various coastal countries, Philippines, China, Vietnam included, no? And the extension of jurisdiction of states because of the developments of UNCLOS, okay, the United Nations Convention on the Law of the Sea. Before UNCLOS, there was no exclusive economic zone, but during the negotiations, the concept was raised, no? It was introduced into the international community and countries began claiming EEZs before the negotiations were concluded. And the Philippines was one of those countries that made an early effort to claim an exclusive economic zone. So you had PD 1599 issued in 1978, which claimed an exclusive economic zone for the Philippines extending 200 nautical miles from its baselines. The baselines of the Philippines at the time were defined in RA 3046 as amended by RA 5446. Okay. Now, that exclusive economic zone of the Philippines was already in place by the time that UNCLOS was actually, the negotiations were actually concluded, and it was open for signature in 1982. Okay, so we were ahead actually of UNCLOS in defining and declaring our exclusive economic zone. And when UNCLOS entered into force in 1994, it's about 12 years later, the Philippines basically had already been trying to enforce its EEZ rights, even though the fishing activities in the region were still relatively, well, shall we say, not yet bothersome, because it wasn't that high, or that there wasn't that much activity taking place in the area. Most of the activities, the fishing activities, were taking place close to the coastlines of the surrounding countries. Okay. But by the late 1990s, things began changing. The biggest change for us was when China basically surreptitiously established an outpost on Mischief Reef, which is very close to the Philippines. Okay, it's about 125 nautical miles away. Okay, well within our exclusive economic zone. Okay, during that time, 1995, of course, that raised a furor, but unfortunately, most of the Filipino population probably did not give it much attention. Okay. And in 1999, China expanded its initial facilities. At first, there were a few huts, but in 1999, they expanded it into a full-blown building with several floors, even a basement, and a helipad and gun emplacements. And that caused another furor. It was at this time that I actually became involved with government, because I had returned from my master's, and one of the first things we did was to provide technical support to the Department of Foreign Affairs in trying to negotiate with China over this development. Okay. Now, well, the long and short of it is that at that time, China basically told the Philippine panel that it assured the Philippine panel that these facilities on Mischief Reef were, number one, only fishermen's shelters. Number two, they were reserved for civilian use only. And number three, that they would be open to joint use by the Philippines and China of these facilities when conditions were ripe. Okay, so that was the term that was used. And basically, that was how that phase of the negotiation ended. Okay. Now, fast forward to several decades later. Okay, what do we have on Mischief Reef? An entire artificial island with a full-blown military, naval, and air base. Okay, so that gives you an idea of how different it was in the 1990s. How so different the commitments made are from the situation now. What happened? Okay, in the 1990s, because of Mischief Reef, after some more research that we did, we realized that using Mischief Reef, China was basically able to extend its fishing operations further down south. And there was a correlation between the presence of the facilities at Mischief Reef in the 1990s and a visible increase in Chinese fishermen being arrested along the shores of Palawan. And it came to the point that by around 2004, 2005, 2006, we were even arresting these fishermen, not only on the west coast of Palawan, but even inside the Sulusi and Tubataha Reef. There was a time that we that the Philippines detained over 200 Chinese fishermen, and they were all incarcerated in Puerto Princesa City. And at the time, we visited, even paid a visit to that to try to find out what was going on the ground and how the people were reacting, etc. So that's when you basically saw the start of more and more fisheries operations, fishing operations of China, closer and closer to the Philippines. Okay. Now this is happening. While this is happening, of course, we are continuously asserting our exclusive economic zone rights, because some of these fishermen, Chinese fishermen, were caught, say, in the Calayan Island group. And we also caught some fishermen in Scarborough Shoal. So in those cases, there was an attempt on the part of the Philippines to enforce its fishery laws, to exercise its exclusive economic zone rights through these arrests and detention. What happened to those fishermen? Well, eventually they would be released back to China as part of the diplomatic, part of the conduct of diplomatic relations. But we were concerned at the time, of course, about whether the Philippines was actually asserting its EEZ rights, its fishery laws, enforcing its fishery laws, shall we say, forcefully enough, whether it was doing so properly in light of this growing number of incidents. Now, a pause was, despite the increasing incidents, and the occasional tensions, there was a pause in this because on account of the activities of the Philippines, we were able to negotiate with China at least the 2002 Declaration of Conduct. In the 2002 Declaration of Conduct, the objective that we had set out was to at least freeze the status quo, basically get all the claimants to not increase their holdings, the positions that they had already occupied in the West Philippine Sea, and the South China Sea, and to exercise self-restraint, okay? Not take actions that would aggravate the disputes or make it even more difficult to resolve, okay? So freeze, status quo, patas lang lahat. At the time, everyone was basically holding small outposts in the South China Sea, in the Spratly Islands region, okay? And this was basically the situation until around 2010, 2011, 2012. Why? What was taking place? Well, China had decided to begin pushing or asserting its claims by sending its fishing fleet further into the Spratly Island region. There was a visit, for example, by President Xi Jinping to Tianmen, and they were there was a very prominent speech he made to the fishermen's associations there that they should go further south and fish, in the Spratly Islands region as a way of asserting their sovereignty, okay, over this area. Also, that by that time they decided that it would be better for them to begin not only fishing but also asserting more strongly their claims in the South China Sea. Why? Because in 2009, it became clear that the Southeast Asian nations had begun to align their respective claims in the South China Sea, and they began adjusting them in accordance with UNCLOS, with the United Nations Convention on the Law of the Sea. The Philippines enacted RA 9522. Vietnam and Malaysia filed a claim for an extended continental shelf jointly, and Vietnam also filed a unilateral claim for another area of extended continental shelf. Brunei had indicated that it would be making a claim consistent with UNCLOS, and Indonesia had already negotiated its continental shelf boundaries, but was indicating that it was also going to make a claim for an exclusive economic zone, all of them in accordance with UNCLOS. So the Southeast Asian nations were all reaching a common ground of adopting and applying UNCLOS to their respective claims in the South China Sea. China responded by digging in on its own claims, not based on UNCLOS, but based on an ambiguous claim to historic rights or title or facts, depending on which statement it is that you look up. Okay? What the point was that it was essentially claiming most of the South China Sea, and I assume that most people here would be familiar by now with the infamous line 9-dash line. Okay, 9-dash line map, which basically encompasses most of the South China Sea and incidentally deprives the surrounding Southeast Asian states of their respective exclusive economic zones. Okay, so that was what was happening while the Southeast Asian nations were aligning in accordance with international law. China chose an exceptionalist position, no, and was pushing its own unilateral claim. That resulted in frictions, more frictions among between China and the Southeast Asian states. In the case of the Philippines, it began manifesting in terms of interference with our fisher folk, their fishing activities. There was an incident where a Philippine vessel exploring for oil on Reed Bank was interfered with. And there was a protest lodged by China against our own attempt to encourage petroleum exploration in our exclusive economic zone in continental shelf. No? And as you know, by April 2012, this came to a head with a standoff between China and the Philippines in Scarborough Shoal. Okay? What sparked that off was an attempt on the part of the Philippines to arrest Chinese fishermen that were conducting illegal fishing operations on Scarborough Shoal. They were taking giant clams and endangered species. They were destroying the coral reefs on Scarborough Shoal. China moved in to protect them and prevent the arrest, and that led to several months of a standoff. Okay? And in the end, China ended up with control of the reef and the Philippines with nothing because it withdrew on account of an agreement, supposedly, that the two countries would mutually withdraw from the reef. Okay? In the end, the Philippine government decided to file a case in accordance with UNCLOS Part 15 and Annex 7. It is now known as the South China Sea Arbitration. Okay? That was the only legal recourse left to the Philippines because, well, our own constitution prohibits the use of force. No? We will never use war as an instrument of national policy. Okay? So diplomacy and peaceful dispute settlements are our only recourses in these types of instances. And so we did. Since diplomacy was ineffective, we resorted to the options available to us, and that was the legal option of resorting to arbitration under UNCLOS Part 15 and Annex 7. As you know, that ended after 3 years. It ended in a near total victory on the part of the Philippines. Some 98% of what we had asked for was actually granted, and our rights, our position was vindicated. No? But what was actually contained in this arbitration is the subject, again, of much confusion. Okay? Because, well, aside from the fact that the underlying disputes themselves were complicated, no? The case itself was also necessarily very complicated. So to start off with this, to level off on this, let me just explain very briefly the most essential points. What did we win in that arbitration? It's 501 pages long, no, if you try to read it, but just out of that 501 pages, keep in mind only 5 points that I will now illustrate, as you see on the map. So this is the Philippines, of course, and that's the South China Sea in the middle. The West Philippine Sea, by the way, does not refer to the South China Sea. The West Philippine Sea under AO 29 series of 2012 refers specifically to the areas under Philippine jurisdiction. Okay? And that includes our exclusive economic zone and the waters around the Calayan Island Group, meaning the territorial seas around the Calayan Island Groups. Okay? Now, in the arbitration, in the end, there were 15 submissions with several other sub-submissions, meaning you can divide some of them even further. But the 5 main points to keep in mind are these. One, China does not have any valid historic claim to the South China Sea to the extent of the entire 9 dash lines. Okay? Any claim of China to jurisdiction within the South China Sea can only be made in accordance with UNCLOS. And if you apply the rules of UNCLOS properly, best case scenario for China would be a much smaller portion that is indicated on this map, no, illustrated on this map by the dotted line there, no. It's basically very much closer to the Chinese coastline, no? And that's their best case scenario. Their exclusive economic zone cannot extend much further than the 200 nautical miles from their own mainland coast and possibly the paracels if those will generate their own exclusive economic zones and continental shelf. Okay, if they don't, then the minimum case would be much closer. Now, because of that, there is no overlap between a Chinese EEZ or continental shelf and the Philippine EEZ and continental shelf in the Spratly Islands region down south, no? Meaning in the Calayan Island group, in the area of the Calayan Island group. They have no EEZ or continental shelf rights in that area. They cannot have any. It is only the Philippines that has that. Okay? The Philippines is fully entitled to its full 200 nautical mile EEZ and continental shelf extending from the west coast of Luzon, Mindoro, and Palawan. And that, as I mentioned earlier, comprises the majority of what we now refer to as the West Philippine Sea. Okay? Within this area, however, where is the yeah. We have, however, the islands and rocks that we mentioned earlier, no? That are subject of sovereignty disputes. Okay? These islands and rocks, after the analysis of the tribunal, they found that they are entitled only to 200 nautical mile territorial seas, not exclusive economic zones and continental shelves of their own. And because of that, it is because of that that China cannot claim any exclusive economic zone or continental shelf areas that far down south. Okay. If at all there is an overlap between a Philippine EEZ and continental shelf, it will have to be somewhere up north, closer or more adjacent to perhaps Ilocos and Batanes, but not all the way down to Palawan, to the area west of Palawan or Mindoro. Okay, that is the implication. Okay? And since these areas are now subject to territorial and sovereignty disputes, those are the only areas that are legitimately disputed between the Philippines and China. So, as you see on the screen, those small dots at best. Now, this is, of course, not a technically accurate drawing. This is only for illustration. Huh? But you can just imagine that within the Philippine EEZ and the high seas beyond it, there are those small areas where you have sovereignty disputes. Those are the only legitimately disputed areas between the Philippines and China now, no? Based on the South China Sea Arbitration Award. Outside of those areas, the waters are either Philippine EEZ or continental shelf, or they are a part of the high seas beyond 200 nautical miles. Okay? If it's the high seas beyond 200 nautical miles, all states have basically equal rights. Okay? But within 200 nautical miles from Palawan and Mindoro and Luzon, that's the Philippine EEZ and continental shelf, the rights there are clearly divided between the coastal state, i.e. the Philippines, and the use and other states, no? Which I'll go into more detail in a couple of slides from now. Okay, but just keep that in mind that the only legitimately disputed areas are much smaller now than what they used to be, and the Philippine EEZ and continental shelf has largely been vindicated by the tribunal. Okay. Now, since the tribunal was able to tell now, we can now tell where are the legitimately disputed areas and where they are not, okay, the tribunal then proceeded to rule on the many different complaints, shall we say, of the Philippines about China's activities. Okay, things like using water cannon on our fishermen, or protesting a petroleum concession contract that we had issued, or conducting fishing within our EEZ, no? Or their Coast Guard protecting their fishermen while they were fishing close to, say, Palawan, or close to Scarborough, etc. Okay, all those various issues, the tribunal mostly, for the most part, could tell whether they were undertaken in contravention of our rights to our exclusive economic zone and continental shelf. And for the most part, no, you can just refer to the arbitration for the really, extended details. But for the most part, the tribunal found that China did indeed contravene our rights, no, our jurisdiction in our EEZ and continental shelf. One of the most important aspects of these findings was the status of mischief reef. No? Mischief Reef was found by the tribunal to be part of the Philippine continental shelf insofar as the seabed is concerned, and part of the Philippine EEZ insofar as the waters are concerned, because Mischief Reef was a totally submerged feature before China built an artificial island thereon. The tribunal also found that Ayungin Shoal or Second Thomas Shoal was part of the Philippine EEZ and continental shelf. Okay, and therefore when with respect to, and also with respect to now the construction of the artificial islands, 7 artificial islands within the Philippine EEZ, China had also contravened Philippine rights and jurisdiction over its EEZ. China had also acted contrary to international law. Okay, now Mischief Reef is the only one where the status was ascertained to be part. Its status was ascertained that it was part of the Philippine EEZ, the continental shelf. The 6 other artificial islands of China, unfortunately, the tribunal could not make a ruling on their status because they were inside what are called high tide elevations, okay, meaning rocks, which generated an area that is subject of a territorial dispute. Okay, so because of that, they could not rule on the exact status of those artificial islands. All they could say was that the act of constructing those artificial islands was in itself also contrary to international law. Why? Because they were done while the case was pending. Okay, they were done to change the facts on the ground and make it very difficult, if not impossible, for the issues to be resolved fairly and equitably. Kumbaga nandaya sila. And because of that, the construction of those artificial islands, all 7 of them, were contrary to international law. Okay, but it did not go much further than that. Okay, why? Well, the Philippines didn't ask for anything else from the tribunal, for one, and second, that was really quite frankly a very novel situation that was created, no, while the case was pending. Okay, so I would assume, for example, I would speculate, and this is a speculation on my part, I would speculate that the Philippines did not want to complicate the legal issues even further by adding on questions for the tribunal to resolve. Okay, after all, you had already a long litigation with many complicated issues, no? And it was in the interest of the Philippines to have the case resolved as soon as possible. Okay, so these 5 points are the most important things to keep in mind about the arbitration case. Okay? Anything else can be more or less resolved by them, but you have to keep in mind also what was not resolved. Okay, the South China Sea arbitration did not solve everything. Okay, did not solve everything. There are still unresolved and pending issues. Okay, so for example, 1, the exact baselines and maritime boundaries around these disputed islands and rocks. Those were not defined by the South China Sea arbitration. Okay, the tribunal only determined whether they were entitled to have these territorial seas extending up to 12 nautical miles, but they did not define where exactly the boundaries of these territorial seas were. They did not determine exactly which features had these. No? There are many features in the Spratly Islands region, in the Calayan Island Group, Depending on whose map you're looking at, you can be looking at, and whose law you're looking at, it can be anywhere between 20 to 150, depending on how they describe it, how detailed their maps are, how detailed their legislation are. Okay, so there is basically a little bit still of uncertainty as to boundaries. Second point, the tribunal did not answer any question as to what is China's international liability or responsibility for the damage it caused in constructing those artificial islands and in contravening Philippine rights in its exclusive economic zone in continental shelf. No? The act of constructing those artificial islands, in addition to having been done while the arbitration was pending, no, it was also contrary to international law because it contravened China's duty and obligation to preserve and protect the marine environment. Okay. Now, naturally, if you contravene a duty or obligation, an injury may be caused and damages may be forthcoming. No? But there was no issue of computation of damages. Okay, so whether that can be translated into a monetary amount, no, that question was never raised in the South China Sea Arbitration Award. Okay. Besides, at the time, the tribunal, no, basically, you can read through it, but basically, up until that time that the award was handed down, there was still uncertainty in the legal status, the legal situation in the area. So you cannot say for sure whether there is a violation of rights before the tribunal actually made its decision. No? And so the question of whether or not damages are forthcoming, no, could not yet be properly put in issue. No? That could only be done after the award has already been handed down. Okay. Now, but that's just suffice it to say that there is no indication there as to how much is payable and what is payable, etc. Okay. Third point, although the tribunal declared that the artificial islands were constructed contrary to Philippine rights in its exclusive economic zone and continental shelf, contrary to China's duty to preserve and protect the marine environment, it did not say what would be done after that. Okay? The Philippines did not ask the tribunal for any guidance on what to do with these artificial islands. As I said, it was a novel situation, no? And it would have been best left to, and presumably to, negotiations, no? The continuation of relations after the award has been handed down. Okay? Fourth point, sovereignty over any of these disputed islands and rocks, that's whether it's the Clan Island Group or Scarborough Shoal, no? That question was never resolved by the tribunal. And at every opportunity, the tribunal took care to point out that it was not making any statement either for or against any party with respect to sovereignty over these features. Okay? No ruling at all either way. Okay? Now, why? Because that is beyond the jurisdiction of the tribunal. The tribunal was established for the interpretation and application of UNCLOS, which deals with jurisdiction over the sea. It does not deal with sovereignty over land features. Okay? Fourth point, the maritime assertion activities of China, as I mentioned, most of them, the tribunal could make a ruling on whether it was contrary to our rights or not, except for the activities around Second Thomas Shoal or Ayungin Shoal, where you have the BRP Sierra Madre run aground there and manned by a small outpost of Philippine Marines. Okay? Yes, the activities of China against the outpost there, the harassment, shall we say, that the tribunal could not make any ruling, could not say anything about it because it was deemed by the tribunal to be involving military activities, and military activities were beyond the jurisdiction of the tribunal. Okay? At best, the tribunal was able to rule only that Ayungin Shoal, no, was clearly part of the Philippine continental shelf and EEZ. No? But the activities around it, the harassment by China, it wasn't able to make a ruling thereon. Okay? And lastly, the South China Sea Arbitration basically resolves some issues, only some issues, between Philippines and China, particularly some of the legal issues. It does not purport to solve any other disputes in the South China Sea, such as the dispute that stands between the Philippines and Vietnam, the Philippines and Malaysia, no, between Malaysia and Vietnam, between Brunei and Malaysia and the Philippines and whoever, no, those were not resolved by the South China Sea arbitration. Okay? And you need to appreciate the complexity of the remaining disputes, but at least, no, at the very least, we have some more clarity, a lot more clarity now than before. Why? Because the Southeast Asian countries, as I mentioned, all began aligning their positions, their claims in accordance with UNCLOS. It is only China which has not done so. And because of that, the disputes, at least between the Southeast Asian countries, there is now a common ground. They're all applying UNCLOS. And since 2016, various countries such as Vietnam, Malaysia, Indonesia have all pointed to the South China Sea Arbitration Award, the reasoning therein, the rulings therein, to be the proper interpretation and application of UNCLOS to the South China Sea. Okay? And that means that their respective claims are also aligned with the implications of the arbitral award. And that means that we now have some light at the end of the tunnel. It may actually be possible to resolve the disputes using UNCLOS as the basis, if only China would follow the lead of the Southeast Asian countries. But now, the legal situation, therefore, is something like this. Again, this is only for illustrative purposes. China cannot claim the entire South China Sea to the extent of the 9-dash line. At best, its claims at maximum would look like what you see there on the screen as the red line, with the dotted lines being still uncertain. Okay, but that would be their best case scenario, their maximum claims. The Philippines, on the other hand, was able to vindicate its claim to its exclusive economic zone in continental shelf in the South China Sea. That's what we now refer to as the West Philippine Sea. Okay, and the only additional area there would be those small enclaves of territorial seas around some of the Calayan Islands, including Pagas Island, which happen to lie outside of that 200-mile line. Okay, but the point is that at least with respect to EEZ and continental shelf rights, no, the Philippines is now standing on clear legal grounds. Okay, we can even lay a claim to an additional seabed area, not the waters, but only the seabed, and claim the resources of the seabed in that area of the South China Sea, in the middle area, underneath the high seas. This can be part of our extended continental shelf, similar to our extended continental shelf in the Benham Rice region, or what we now refer to as the Philippine Rice. Okay? However, the Philippines has not yet taken the step of actually making the submission to this area, no? Because you need to make a submission before the Commission on the Limits of the Continental Shelf to do that, to clarify that you're claiming that area. Despite our recommendations, the government has, the two administrations, Aquino and Duterte administrations, they have not acted on that recommendation to actually make that submission. Okay. Vietnam has aligned its claims with UNCLOS. In fact, they even supported the Philippines in the case by submitting a legal position, agreeing with the Philippines' legal position that essentially the states are entitled only to areas in accordance with UNCLOS. And so Vietnam is claiming its 200 nautical mile EEZ and continental shelf from its mainland only. It's not making claims extending from the islands, no, which it also claims. And it has made the claim for extended continental shelf areas, the ones that are in orange on the screen, no, which create that irregular shape. At least beyond the 200 nautical miles, they're only claiming seabed resources in those areas. But that essentially shows you the maximum extent of Vietnam's claim. Okay. Now, Malaysia has also indicated that it is abiding by UNCLOS, and it did so when it made a joint submission with Vietnam for that area between them, between the EEZ and continental shelf down south, that orange area on the bottom, that was jointly claimed by them. No? And so Malaysia is making a claim consistent with UNCLOS as well. Okay? And Brunei has submitted what is known as a preliminary information paper indicating that it will also make a claim for an ECS in that area, and therefore also implying that it has aligned its claims with UNCLOS as well. Indonesia has already negotiated its continental shelf boundaries with all of its neighbors, and the only thing left is for it to negotiate EEZ boundaries. Okay? And for now, it is claiming, it may be seen to be claiming at minimum that area covered by the yellow line that you see there on the bottom of the screen. That would be the maximum extent of its EEZ. Okay? And I'm sure that they are also now trying to negotiate these boundaries with those respective neighbors, because this is a separate negotiation from their seabed boundaries. Okay, so this would be the status of the South China Sea disputes among all of the disputing parties if you were to use UNCLOS, no, as the common ground. Okay, and you can see that although it's still a little bit complicated, the fact that they do have common ground means that there is more or less some hope that they can be equitably resolved in the future given enough diplomatic effort and political will. The problem, of course, is that China is not playing by these rules and is insisting on still claiming almost the entire South China Sea, which would leave most of these surrounding Southeast Asian states, no, with much less than what they are entitled to under international law. Okay? So, what is our current situation? Basically, we have committed to abide by UNCLOS, especially when we went through that arbitration. If you apply the maritime zones in accordance with UNCLOS, this is more or less what the configuration would look like. You have the baselines in red. The waters inside the baselines are archipelagic waters, okay, as well as internal waters in some cases if we decide to separate them. But in that area, we have absolute sovereignty over the land. No? Over the land areas, it's total and absolute sovereignty, the total plenary power of the state. Okay? In the waters outside of the land, no, basically from shore, it is our archipelagic waters. We have absolute sovereignty as well over them, subject only to a concession in favor of the international community of allowing foreign vessels to pass through. Okay? It is similar to the situation in the territorial sea, no, which is the area covered by the orange line that you see on that map. In both the archipelagic waters and the territorial sea are under our sovereignty, subject to the compromise that we allow, or the concession that we gave to the international community, that we will allow them to pass through. As long as that is the only thing they're doing, merely passing through, not anything else, not fishing, not smuggling, anything, then they're allowed to do so. If they do more than merely pass through, then our rights as a coastal state will kick in, and we may be able, depending on the circumstances, we may be able to carry out law enforcement. Okay? It all depends on the particular situation. Okay? Beyond the territorial sea, at 12 nautical miles, up to 200 nautical miles, which is the blue line, that is our exclusive economic zone and continental shelf. Okay. Under UNCLOS, we don't have to do anything. We already have a claim to that, PD 1599. And so essentially that was just validated by UNCLOS. We still retain that claim, that EEZ zone extending up to 200 nautical miles. And with respect to the continental shelf, again, we also do not have to do anything, no, because we've always been claiming a continental shelf anyway since 1947. And basically, UNCLOS recognizes that as well. And in fact, when it comes to the continental shelf, we're referring to the seabed, UNCLOS increased clearly our continental shelf by allowing it to be extended up to 200 nautical miles, i.e. to coincide with the exclusive economic zone. Okay? In that area, we do not have absolute sovereignty. What we have are sovereign rights. And this is another point of confusion, because most people seem to make the assumption that just because the word sovereign appears, automatic that is equivalent to sovereignty. Okay, that is not the case. When you say sovereign rights, no, the best analog to this is that it's a property right. No? We have sovereign rights to the living and non-living resources within that area. Okay, those living and non-living resources, whether it's fisheries, minerals, oil and gas, those are ours, no, under UNCLOS. And when we say exclusive, no, in the context of UNCLOS, whether it's exclusive sovereign rights or exclusive economic zone, what it means is that the right to decide, no, what is done with these resources is exclusively ours. We have, kumbaga, first dibs. It is we, no? It is the coastal state that decides what to do with them, who should exploit them, how, who should benefit from them. Okay, and if we chose to share it, if we choose to allow other states to also take these resources, that must be done with our consent and in accordance with an agreement, no, with a treaty with us, because we have the right, we can regulate even foreign states who wish to partake of our resources in the EEZ and continental shelf. Okay, so that's why it is akin to a property right. You can do what you need to do in order to protect that property right. Okay, but I'll go into more detail when we go to the next few slides. Okay, now beyond the 200-mile line, no, we can lay claim to an additional seabed area, no, not the waters above it, but just the seabed, and that is our extended continental shelf. Okay, that's sometimes we refer to it as the ECS, and we've already made and validated our claim to the Benham Rice region. That's the area on the left. That's why there's a bulge there. Okay, that has already been recognized by the CLCS and the international community. There is no problem anymore with that. Everybody knows that that is ours. At least the seabed resources there are ours. And we can also, as I mentioned, lay a similar claim in the west, in the west, no, beyond the West Philippine Sea. Well, that is the potential ECS in the Western Palawan region. If we were to have that claim made and recognized, validated by the CLCS, then that would become part of the West Philippine Sea clearly, because it is also going to be under our jurisdiction. Okay, but for now, that claim has not yet been made. We have only indicated to the international community by means of a note verbal last year that we do intend to make such a claim. Okay, so just the intention. But the actual delineation, the boundaries, etc., hindi pa nagagawa yun. Okay. Now, let's go into detail on this. What is now involved in our EEZ and continental shelf rights? When you look through UNCLOS and you look at the detailed provisions of the articles there, no, especially the EEZ, okay, these are our rights as a coastal state. We have sovereign rights to the living and non-living resources. As I mentioned earlier, that's like a property right. That includes all necessary jurisdiction, no, necessary laws and regulations in order to protect that right to those living and non-living resources. Okay. We also have jurisdiction over certain activities like marine scientific research, the establishment and use of artificial islands and installations, and the protection of the marine environment. In other words, we should determine the rules for these activities subject to the provisions of UNCLOS. Okay. And then other rights as provided in the convention. No? Of course, these are now scattered all over the convention, and it will depend now on the circumstances. Okay? Included in our rights is the right to conserve and manage the living resources, particularly when you're talking about the EEZ, including the determination of the total allowable catch, the determination of whether there is a surplus, meaning a portion of the living resources that we cannot harvest, and the determination whether we want to share that surplus with other states, but always on the basis of a specific treaty or agreement with that state, no? A fisheries agreement. Okay. For now, however, according to our constitution, such agreements are not allowed. Why? Because the constitution reserves fishery resources exclusively to Filipinos. Okay, you'll find that in Article 12, Section 2, Paragraph 2. Because of that, we are not sharing. There is and any attempt to share these resources is unconstitutional. And that is implemented by our Fisheries Code, RA 8550, as amended by RA 10654. And included in our rights is the right to take such measures, including boarding, inspection, arrest, and judicial proceedings as may be necessary to ensure compliance with our laws and regulations in conformity with UNCLOS. So, if any of these laws and regulations in order to protect and assert our sovereign rights to living and non-living resources are violated, or if there is a violation of our rules on the regulation of MSR, establishment of artificial islands installations, or protection of the marine environment, we are allowed to take such proceedings as may be necessary to ensure compliance by other states. Okay, by other states. Okay, so yung mga foreign fishing vessel, for example, yes, we can carry out enforcement against them. We can board, inspect, arrest, and carry out judicial proceedings. The only limitation that UNCLOS has is that we should not arrest fishermen, meaning detain fishermen, and this is more on humanitarian grounds, unless there is an agreement, a specific agreement that allows such detention. And we should allow the release of the vessel subject to the filing of an equivalent bond, meaning a monetary value, the monetary value of the vessel, or a security bond to secure the release of the vessel, as well as to answer for the violation. Okay, the rationale behind that is humanitarian considerations, because kawawa naman yung foreign fishermen, they are locked up in a country other than their own. Okay, but that was the rationale. That was the rationale for that. Okay. Now, regardless, as you can see, the coastal states' rights to EEZ and continental shelf, its right to conserve and protect its sovereign rights, its living and non-living resources, that should not be questioned. Okay, we have that. Other states, on the other hand, have rights. Yes, they have rights in the EEZ and continental shelf, but they're rather limited, to physically to freedom of navigation over flight and the freedom to lay submarine cables and pipelines. Yun yung mentioned. However, the opening for them would be other internationally lawful uses of the sea related to these freedoms and compatible with UNCLOS. So, other states also have rights within the EEZ continental shelf as long as those rights do not interfere with or undermine the coastal state's rights to its living and non-living resources and its jurisdiction over marine scientific research, artificial islands installations, and protection of the marine environment. That has to be clear. Okay. Other states have duties as well to the coastal state. Okay. Now, other states have duties to give due regard to the rights of the coastal state to its EEZ and continental shelf, and to comply with the laws and regulations of the coastal state adopted in accordance with UNCLOS and international law. That includes fisheries laws and regulations. Okay, so foreign states in the Philippine EEZ have a duty to comply with our fishery laws and regulations. Okay, and the Philippines, on the other hand, as a coastal state, only has a duty to give due regard to the rights of other states, meaning if they're merely passing through exercising freedom of navigation over flight, if they're merely laying submarine cables and pipelines and not doing anything else, they're not undermining our rights to our EEZ and continental shelf, then that's fine. We can allow that. Okay? But that does not mean that we give up totally. Okay, now. So, klaro, yan yung rights and duties that are involved now in considering what is happening dito sa Julian Felipe Reef now. Okay? Julian Felipe Reef or Whitsun Reef is a submerged feature. It happens to be 175 nautical miles away from, I think it's Rizal, Palawan. Okay, that's the closest. 175 nautical miles, meaning it's located within the exclusive economic zone. Okay. However, it is also within 12 nautical miles of a high tide elevation. There's McKinnon Reef and Grierson Reef. And so there is the possibility that Whitsun Reef, being within 12 nautical miles of those high tide elevations, could also be subject to a legitimate sovereignty dispute. Okay, could. Why could? because the tribunal did not define the boundaries of these territorial sea zones around the high tide elevations, did not even identify all of the high tide elevations within the Spratly Island region. Okay, as I mentioned, they did not solve everything. Okay, so here it so happens that only McKinnon Reef, was dealt with by the tribunal, no? And it was found to be a high tide elevation. Whitson Reef itself is not mentioned because it was not put in issue. Okay, so yeah, so you have possibility that it is subject of a sovereignty dispute. Okay, why is it a sovereignty dispute? Because the Philippines is also claiming all of the high tide elevations within the Calayan Island Group area defined in PD 1596. Okay, when PD 1596 was issued, there was no EEZ. The territorial sea wasn't even sure what is the maximum extent of the territorial sea back then. No, but it basically made a claim to the Calayan Island Group, describing it similarly to the way that the Treaty of Paris describes the Philippine Islands, or what comprises the Philippine Islands, by drawing a box around all of these islands. So that's what we also did with PD 1596. We drew a box around what we considered to be the Calayan Island Group. Okay. So all of the high tide features there, including McKinnon and Grierson Reef, the Philippines therefore is also claiming to be under its sovereignty. So you have overlapping possible basis for the exercise of Philippine rights. Now, what happened, however, is something a bit new. No? Whereas before, it was clear. No? I mean, the nature of disputes was clear before because it's either there are other states that have put in place structures on these various islands and reefs, or later on you had fisheries problems with fishing activities or law enforcement activities. No? What happened on Whitson Reef was that the Philippines monitored the assemblage of 220 vessels of the maritime militia of China. Okay, and it was unusual, quite unusual and surprising because that had never happened before. The anchorage and assemblage of so many of these types of fishing vessels, which also happen to be maritime militia vessels. Okay, Whitson Reef is there on your upper right-hand corner. A picture of the fleet taken about 2 weeks later is on the left, upper left, and a close-up of one particular group is on your lower left. Because the picture was clear enough, it was possible to discern the names of these vessels and check their activities using the automatic identification system records. Now, these are commercial transponder records which show their positions over a period of time. And so on the right is an example of what came out when the records were checked of concerning some of these vessels. Okay? And what is clear from those records is that even though they look like they're fishing vessels, they never fished. They basically went straight to specific features, stopped there, and then moved on to the next feature, and then the next, and then the next, and then went back. Essentially, it is a patrol. Okay, it looks like a patrol, and that's why it corroborates the statement of the National Task Force on the West Philippine Sea that these vessels are actually maritime militia vessels, not really fishing vessels. Why was this such a problem? Okay, well, you have to remember that for the past couple of years, since 2018, the armed forces has monitored the presence of fishing vessels around Pag-asa Island. And the thing is, even though they're fishing vessels, they're never seen fishing. They're always just standing there. There's nakatambay lang. They just sit there until they're relieved by another vessel. And the other thing they do is that every time somebody from Pag-asa Island tries to approach a nearby feature, Sandy Cay, these vessels start moving and interfering so that you don't reach that cay. No? And once they start moving, the China Coast Guard also comes to try to keep you away
no, from Sandy Cape. Okay? And the armed forces also observed that it wasn't just happening around Pag-asa Island. They were now seeing these vessels also taking up stationary positions near some of the other Philippine islands like Kota and Panata. Okay, and they were there continuously. They're fishing vessels but never fishing. Okay, so those were clearly maritime militia vessels based on their activity. Okay, and so now all of a sudden you see a huge number converging on one particular spot, no, on Whitsun Reef, no. Now, the thing is, prior to this, no, activities of the maritime militia vessels had also been noticed before. No? It's just that they were never in this big a number. And when you look at the records, what is happening, what has actually been happening on Whitsun Reef, is that they have established basically a continuing presence using these vessels. They were using Whitsun Reef as an anchorage. Okay? And that is a concern because by establishing a continuing presence, no, that could potentially be contrary to the commitment of the parties not to inhabit any unoccupied features, no, which commitment was made in 2002 through the Declaration of Conduct. Okay? That's one element, as I mentioned. The second element, no, that is of concern is that if these vessels, by virtue of their presence, no, are then guarded or protected by the China Coast Guard, and they begin to shoo away Filipino fishermen from that area, prevent them from coming even near because of their need to secure the vessels, then you will have a situation where the Philippines will again lose control of a maritime feature by virtue of exclusion and continued presence by China. Exactly the situation in Scarborough Shoal. Our fishermen are not allowed to go inside the shoal, and the China Coast Guard are always there, no, ready to ward them away. In some instances, they even water cannon them and ram them, damage their outriggers, no. And Philippine government vessels are always warned away whenever they appear to be approaching Scarborough Shoal. Okay, so you have the elements, the elements of that situation apparently being seen on Whitsun Reef. Okay, the thing with Whitsun Reef is that you have to also you have to remember that prior to this, in 2017, there was already a report that Filipino fishermen were being warned off this area, which happens to be part of Union Bank. No, there will be that warning shots were being fired against them to try to discourage them from even approaching this area. So you put two and two together, and you have the possibility that this could be a prelude to another occupation. And that naturally raises worries and concern. Okay? And I suspect that that is one of the reasons why the National Task Force on the West Philippine Sea had to reveal the presence of this, and why the government then had to take action to try to get these vessels to disperse. Now, the problem was aggravated when the Chinese embassy, in response to the protests of the Philippines, responded by saying that these vessels are only taking shelter from bad weather conditions. Okay? Number one, there were no bad weather conditions detected for quite a long time. It's sunny. No? So unless they're worried that, I don't know if they use glutathione or something, unless they're worried about that kind of weather. No, there's no bad weather in that area for quite some time. But what was more alarming was the excuse that they were there sheltering. No? Why? Because that's exactly the same kind of excuse that they gave on Mischief Reef in 1995, that they were only creating fishermen's shelters. And now you have 220 ships sheltering on another reef. Okay. So naturally, the government would be justified in its concern about the intentions of these vessels. Okay. The other thing that the Chinese embassy admitted was that these were sheltering, they were pausing from fishing operations. And where else could they be fishing? They could not be fishing all of them in that particular reef. They would quickly make short work of that reef. So they were fishing in the Philippine exclusive economic zone. and they're using Whitsun Reef as a base to conduct that kind of activity, which is contrary to our rights, no, to our exclusive economic zone, and contrary to our national laws. Okay, so you have all these reasons why the Philippines should protest the presence and operation of these vessels. Now, whether they're maritime militia vessels, which they appear to be, or even if you assume that they are actually fishing vessels. Okay? So that is the situation. And how does that now jive, no, with our rights? Okay, clearly there are continuing violations of our rights to our living resources in our exclusive economic zone, no? And there are loopholes that are being exploited, including the fact that this particular feature may be within a legitimately disputed area. So what do we do? Okay. The arbitration award, as I mentioned, no, vindicated our rights to EEZ and continental shelf. But the problem is that, number one, the government does not want to use it. Well, at least for the since 2016, no, it has not actually taken action on it. No, and up to last week, it has even describing the award as unenforceable, which for me personally is the wrong way of describing it. Okay. In the international community, enforcement of arbitral awards takes a different meaning. It's a different complexion. It's not like in the domestic situation where you have a sheriff that enforces the court's orders. There is no international sheriff. There's no international police force. There's no third-party enforcer. Why? Because all states are equal. All states have sovereignty, and sovereignty remains supreme even over international organizations. Okay, so in order to achieve enforcement of international law, including arbitral awards, what you need essentially is the voluntary action of states. And the voluntary action of states can only take place as the result of your conduct of relations, which includes diplomacy and negotiations, which includes how you conduct your relations with the concerned states. In order to have that, in order to do that, no, that's not something that happens in a day. That's not something that instantly comes about. It is the result of how you conduct your relations. And because it is a result of that, that means it is dependent on various factors, including most especially relying on consistency and resoluteness in the national posture and policy of the state concerned, no, of the state seeking the enforcement in compliance with that judgment. Okay. Now, that is what we were supposed to do once we won the award. We were supposed to use the award as the basis, as the takeoff point for any further relations with China, whether it's diplomacy, negotiations, or what. The arbitral award essentially already determines what is right and wrong with respect to the West Philippine Sea, no? Who has the rights and who does not. And therefore, you proceed on that as your assumptions in conducting your relations with the other party. Okay? Now, China, as you know, has refused to recognize the award. Okay, well, it's because talo, no. But there is also what has it done as a result of that. Aside from refusing to recognize the award, what is its strategy now? No, if the award continues to be insisted upon, no, if it continues to be valid, China will have a problem not only with the Philippines, but also with other states. Other states in Southeast Asia with whom it has competing claims. Why? Because these other states might refer to this award as the proper interpretation application of UNCLOS, in which case their negotiations will also be affected. And that is exactly what has been happening, by the way, in the past couple of years. Second, they will also have problems with other members of the international community who might begin to see China as some kind of a rogue state because it is not following international law. It is not following a judgment that was arrived at in accordance with the procedures under UNCLOS Part 15 and Annex 7. Okay. So what is the way out for China? Simple. get the smaller countries to give it up voluntarily. Okay? Give in to China's position, give in to its characterization of the waters as being subject to its historic rights, give in, get the smaller countries to recognize China's view or perspective about how the South China Sea should be divided, i.e. mostly China's. Okay? And that is the underlying objective of all its statements, actions, and diplomacy concerning the arbitration and the South China Sea. Okay? And that's why it is important for us to always insist on the arbitration as valid, binding, and enforceable. Okay? Enforcement, as I mentioned, being enforcement in international law, being of a different character than what most people assume enforcement to be, which is the domestic law concept. No? Enforcement and compliance in international law, in a way, will always be a test of national will. Okay, so for those people who study international relations, no, that's why international law is still very important, especially if what you're trying to look for, what you're trying to develop, is an international community where all states are equal, where all states behave in accordance with set and agreed norms of behavior, and not simply on the basis of who is more powerful than the other. Okay. Law matters, and I'll give you some examples. One, probably one of the best ones. The Western and Central Pacific Ocean is now under the jurisdiction, the tuna fishing and the most valuable fisheries in the Western and Central Pacific Ocean are now governed by the Western and Central Pacific Fisheries Commission. It is an international fishery commission that was initiated by the small island developing states, little states like Vanuatu or Fiji or Samoa, no, whose total land area, or when you combine all of them, they're less than the land area of Cebu, and even their population is probably less than a barangay in Cebu. No, that's how small they are as states, and yet they are able, no, to create an international organization that sees to it that their rights to their exclusive economic zone, the fishing, the valuable tuna fisheries there, no, are recognized and respected by all fishing states, distant water fishing states like the US, even China and Taiwan, all of them larger and more powerful than they. And yet, they pay them license fees, no, and they abide by the rules that are created by them through this commission. The Philippines itself is a member of this, and we pay fees, no, to the commission in order to be able to fish in these areas, including their EEZs. No? So that is an example of how law matters. It's not merely a matter of power, size. No, law also can bring up the status, can give power in a sense to even the smallest of nation states. Second, look at what has happened recently. Remember, this is a map. No, this is from Karagatan Patrol, which is monitoring the activities of foreign fishing vessels in our EEZ, as well as commercial fishing vessels within our municipal waters and EEZ. Okay, now, of course, it is very difficult to segregate the Philippine vessels from the Chinese vessels, from the Vietnamese vessels. But look at what's happening in the West Philippine Sea there on the left, okay, to the west of Luzon, Mindoro, and Palawan. Those are mostly foreign fishing vessels. Why? Because when you look at how many commercial fishing vessels we have, they're quite few for the entire country, no? And only a few actually venture out into the West Philippine Sea, no? Most of them are actually concentrated in inter-island waters. And our vessels are also very small. No, if you remember the pictures of Gemver, that's more or less the standard, no, vessel. The only ones larger than that would be carrier vessels where they would where a banca would transfer its catch, no, and the carrier vessel would just bring it back to the shore. Okay, but so most of these are foreign fishing vessels. And this is March 2018. Remember what happened March 2018 at this time, no? The statement of the president was that he was allowing Chinese fishing vessels to fish our exclusive economic zone. So look at that, fiesta. They're all over the place. And you do not see much by way of boundaries there. They're just about everywhere where it's possible to fish. This is March. Parang ano yan, the height of the fishing season. Okay. The following year, more or less the same, except that they're now focused around Scarborough Shoal. Okay. But again, it's just about anywhere where you can fish during that month. This is 2019. Same position, no change yet in the position, no assertion on the part of the Philippines about its rights in the EEZ, no change. But it was during this time that the maritime militia was noticed. And it was the following month that the AFP and DFA complained about the presence of the militia. Last year, still no change, but you had already some indication from the Philippines. This is after the statement that we were made in the UN that we were abiding by the award, we were still upholding it, etc., etc. No? Still very little change, but you can see some marked change because there is, in a way, the bulk in a way is beginning to stay out of the EEZ. This is March this year. Look at how the vessels are trying to stay behind the line, the 200 nautical mile line, no, west of Luzon. Okay, it's not perfect. It's not perfect, of course, but the line is very visible now. Why? Because by this time, the Philippines, oddly, uncharacteristically, was now complaining about violations of its EEZ rights. Okay. This is for a brief period, 27 March to April 2, very short period, so it's not really that significant. But look at April 3 to 9, you still see that pattern of most vessels, at least, still trying to stay outside the 200-mile line. Same thing as of 10 to 16 April. What is different? Well, it is the very public announcements of the Philippines, no, asserting its EEZ rights, claiming and complaining, protesting the presence of this militia fleet, these fishing vessels within the Philippine EEZ. I would attribute that as a direct impact of this, well, so far single instance of assertion of those rights. Okay, so that for me is actually evidence, no, of the effectiveness still of law, no, of assertion of our EEZ continental shelf rights. No. In this situation, they're not useless. They're not. It is not merely a situation of power. Okay. How have we been doing? How can we do this? Well, it is through, well, diplomatic protest is one step, but it is not the only step. Okay. The problem is if you have only a diplomatic protest and you don't do anything else, parang naging pro forma lang, pwede talagang ignore yan. Okay. Its only effect will be to at least establish your legal position. Parang it's in the abstract, and it may not have an effect on the ground. But if in addition to diplomatic protests, you do take actions, no, to assert your rights, such as making statements in public, telling them in public to pull their ships out, making demands to pull their ships out, sending your vessels, telling your fishermen to go out and fish, then it has an impact. Getting the support of the international community as well also has an impact. Why? Because for one of the more unusual aspects of recent events is the fact that a couple of days after the controversy erupted, other states expressed support for the Philippines. The US, Japan, no, and several other countries followed. Even Canada, no, made statements that were in support of our position. No? So that creates some kind of political leverage as well on our part that we were able to employ, and the other party was quite aware of it. Okay? So here you have to remember diplomacy, is not only about talking and bargaining para kang tumatawad sa palengke. This does not take place in a vacuum. In order to be effective, it must be accompanied by other actions. And that also means that effective negotiations require strategy and strength. Okay, strategy in the sense that you are coordinating other actions aside from your diplomatic activity, aside from your diplomatic negotiations, and strength in the sense that you are taking advantage of what strengths you have. And in our case, one of our biggest strengths happens to be law, the arbitration award, UNCLOS, international law, and the support of the international community that results in. Okay? So that's why it's important for us when we conduct ourselves at sea, we must always conduct it or insist on others conducting it consistent with the arbitration award. We should never appease the other parties. We should never surrender our rights or disregard and diminish them. Okay? Because in the end, these are the ones that grant us the greatest leverage, in the course of conducting relations with other states. And lastly, we must always remember that we do this because we want to maintain our independence and autonomy in our maritime activities. And that includes everything from economic exploitation to security and defense activities within our areas of jurisdiction. If we were to simply bow to the power of the other party, let us not fool ourselves or claim to be an independent and sovereign state in that case. Independence and autonomy, sovereignty means the ability to decide on our own, to act on our own, and to exercise our own rights in accordance with international law, in accordance with the agreements that we have already entered into with the other party, and the international community. So we must never soften that stance. We must maintain that strength, and we can do so, in the course of these diplomatic relations, in the peaceful conduct of relations. It's not a binary choice between assertion rights and war. You should never, never believe that it is that simple a choice. No? So, in the end, probably I can only I'll my late colleague, Dr. Eileen Baviera, said when she was asked to review her 40 years of dealing with China. In the case of doubt, this statement comes to mind whenever there may be doubts or questions or complicated issues that come before me. What did she say? If ever one has to take a side in studying, analyzing these disputes, in thinking of solutions, etc., if ever one has to take a side, one must take the side of the Filipino people. Why? Because we're the only ones who can really do that. Don't expect any other country to do that for us. So with that, I end the talk and we'll be open for questions. Thank you very much.
Thank you very much, Dr. J. Batongbacal, for giving us a comprehensive background about this important security issue. Before we proceed to the open forum, we would like to hear the comments and reactions of our discussant, Ms. Ana Patricia Sabiron, member of the Editorial Review Board of the Philippine Strategic Forum. Ms. Ana?
Hi, can you hear me? Confirm lang, please.
Yes.
Okay. Sige. Thank you so much, Professor J. Batongbacal. Good afternoon to everyone. Professor J, your presentation and discussion has been very, very comprehensive, starting from the historical background and then discussing the summary of the arbitral award ruling and how is it applicable and how do we enforce it with us on our side, diba? The Philippine government and the Filipino people. Your knowledge and expertise is very valuable and we are very grateful to have you with us today. A lot has happened in the past weeks and your discussion surely helped us. I'm sure even especially the students of Miriam College and the students of international relations and foreign policy from all over the Philippines. Okay. Recently, President Duterte, I heard his statement from the news that he was saying something like Chinese fishing in the Philippine EEZ is okay, but he would not accept if China starts drilling for oil, natural gas, and other minerals. So I would raise this as a question later on, but just to state it and put it out there. And then on 21st April, there was also a statement from the National Task Force for the West Philippine Sea, wherein they explained that they have deployed ships and other assets comprising of the Philippine Navy, Philippine Coast Guard, and the PNP Maritime Group, so as to protect our fishermen and to assert our rights. So those two things are the developments in the past few days. Now, for my comments regarding the presentation, so we are looking at the intersection of foreign policy, international law, environmental protection, and even human security when we talk of food security and when we talk of the security of our own people, not just the fishermen, but also people from the media. Okay, so it's really a very complicated issue. It's multifaceted. And so I'm sure that's why we have more than 300 participants with us today. So on my first comment, foreign policy. So just let me just share. I'm not a lawyer, definitely not a maritime law expert like Dr. J. Batongbacal here. I'm mostly trained in foreign policy and diplomacy. So I would just like to reiterate what you said, that diplomacy does not exist in a vacuum. So we have international law and then we have diplomacy. So they should be going hand in hand together. It doesn't have to be one or the other. So kailangan talaga, kumbaga, hand in hand sila so that we can get what we want in line with our national interest. And then number two, also taking off from what you said about the importance of international law, this time I want to link it with the international system because we have students here. We know that the international system is characterized by anarchy. So it is very difficult to enforce international law. It's not the same as going to the court in the city, diba? Or in the Supreme Court, and then when you have a decision, someone will enforce that decision. There's the police, etc. But here, this is the international arena, and we are all sovereign states. So it's very important to emphasize this, and it's very important to understand what this means. So going back to what you said about the political will, so it's up to us. We won the award, that's true, diba? And that's a very important legal victory. But then the question always remains that how do we enforce it? And to me, it's not always just about, someone would say, oh, let's call upon our allies, let's call upon ASEAN. Yes, those are also important. Those are strategic partnerships. We have treaty alliance with the United States, for example. But what about what we need to do as a country, as a people? Doon tayo mag-focus, especially when we talk about monitoring the ships, especially about implementing our rights, our laws, diba? Asserting our rights. So dito din papasok yung how many ships do we have, diba? For a long time, AFP modernization has been a very important issue that needs to be addressed, diba? So we look to Congress for that. We look to other stakeholders to help us. How do we help the AFP? How do we help the Coast Guard? And how do we help the PNP Maritime Group? Because these are the people who will be in the front lines, not just the diplomats and not just the fishermen that are out there. Okay, and then for number 3, my comment 3 would be na-clarify na ni Sir yung sovereignty and sovereign rights. Kasi ito pa yung isang issue na nababaliktad nila, and then they keep saying that it's part of our territory. So papasok na yung notion ng territory. So maganda yung discussion ni Sir because meron siyang map, which is one of the things that we need to look at, diba? So that we can imagine ano ba yung EEZ, ano ba yung territorial waters, and saan ba pumapasok yung sovereign rights, saan pumapasok yung jurisdiction, etc. So thank you, Sir, for that. And then finally, my last comment, domestic law. So na-mention ni Sir kanina yung RA number 3046 as amended by RA number 5446, and then there was another presidential decree. I think that was under President Marcos. Please correct me if I'm wrong. But still, there are other legislations that we need to come up with. So we need to push Congress to do it, meaning House of Representatives and the Senate, diba? Because right now, parang we try to look at UNCLOS, pero within the domestic law, may kulang tayo. So kailangan i-fast track din siguro yung mga bills na to so we can fully assert what is ours. So those are my comments. Now for the question, I'll try to pose questions to Professor J. So number one, is there a difference between a diplomatic and a legal approach to solving this problem? So na-discuss mo po ito kanina, pero just to fully emphasize it. So pag sinabi bang diplomatic, negotiations lang. Pag sinabi bang legal, let's just focus on UNCLOS. Ganun ba yon? Or they go hand in hand together? And if they go hand in hand together, how else can we do it right now? Kasi ito yung kailangan natin. So are we supposed to talk with Chinese officials and Chinese officials lang ba, or should we also maximize yung networks natin with their academics, members of the academe, or even local people? Yan. And then number two, knowing that China's aggressive actions has been going on for a long time. So parang for me, I'm not really surprised anymore when I hear about this, diba? So parang since 2012 or far along pa since 1995, ang tagal-tagal na. So how do we approach this? If you would be giving recommendations to the president, to the DFA, to the DND, how do we best approach this? Knowing that China will keep saying that, oh, we're just, these are just shelters for the fishermen. We're just going there because it's bad weather. Mulumang tugtugin na yun, kumbaga. So how do we approach this? Do you have like creative solutions that you can come up with? So that's it for me. Thank you po, sir.
Thank you. Thank you. Ilan bang discussion? Sorry.
Thank you very much, Ms. Anna, for giving us the highlights of Dr. J. Batongbakal's presentation and providing us your own insights about the issue. Professor J, you may respond to the questions of Ms. Anna before we proceed to the open forum. Thank you, sir.
Thank you. Thank you for the comments. I was trying to take copious notes. No? But probably I'll focus on the questions that the last two questions that were sent. Is there a difference between diplomatic and legal approach? Are they separable, or do they go hand in hand? Okay, I would say that these are actually not separable. Okay, it's not an either or situation when it comes to law and diplomacy. Why? Because if diplomacy is about relations, law is also about relations. It's just that law, more or less, is about agreed norms to govern your relations, agreed behaviors or acceptable behaviors. So these can never be entirely separated. No? And anyone who thinks that you can disregard law and just look for a diplomatic approach or negotiate, no? Yung sinasabi nila, wag mong isipin ng batas, mag-negotiate ka na lang. That, I think, is number one, a false dichotomy. And number two, it will lead you down the road of loss of your sovereignty. Why? Because if you're going to disregard law, international law, it's like you're disregarding all of the protection that has been created in favor of the smaller, weaker states by the system of international law that was built up since the end of the Second World War. You'd essentially be going back to the old days of nation states being allowed to do practically anything that they wanted and justifying everything on the basis of their national interest, including going to war, including forcing other states to give up through threats and coercion. So that's why you should never discount the power of law. that is even more important in, as described, an international community which is still largely anarchic, not total anarchy, but anarchy in the sense that there is no overriding superior power that can make any specific state do anything that it doesn't want. No? Otherwise, that would violate its sovereignty kasi. Okay. Now, do they go hand in hand? Actually, when you look at successful diplomatic negotiations, whether it's multilateral or bilateral, take a look at any record that you can find. You will find that number one, those successes are created because of the use of law in addition to the skills of the negotiators. Every diplomatic activity I've been to that I've observed, from the first one about mischief reef to activities I've observed in ASEAN and the United Nations, and activities in international organizations like yung sa Western Central Pacific Fisheries Commission. All of those activities, when you look at the records, whether you're there, you see it actually happening before you, or you look at their records and look at their staff, all of the negotiating teams of these countries will always have their lawyers with them. And the ones that do best have huge delegations comprised not only the diplomats, but also the scientists and the lawyers. Kumbaga, the technical experts are always there, whether it's law, science, or some other related field, no? Basta relevant to the subject of the negotiation. It's never the diplomat alone. It's never about talking and being a good wheeler and dealer alone, no? You basically use whatever strengths you have, no? And law is one of those strengths in our case, no? How do we do it right? Well, number one, in the conduct of your relations, even before there is a diplomatic negotiation on any particular issue, you should make sure that you are always acting, you're always behaving in accordance with your national interests and in a way that the law, no, supports. No? If what is at issue are your legal rights, you better be consistent with your assertion and exercise of those legal rights. Because the moment you do something contrary, you might end up being seen as having given up those legal rights, or having acquiesced to the other party's assertions of their legal rights. Okay? So you have to be careful. You have to know exactly the implications of each action and statement that you're making, no? As you conduct your relations, until the point in time where you actually sit down at the negotiating table. You must always be conscious of that. And as you're negotiating in a bilateral setting, no, or multilateral setting, when you're at the negotiating table, you have to make sure that your diplomatic positioning, your negotiation, is well informed and backed up by international law, whether it's domestic or international. Okay, so it takes quite a bit of work and expertise, no? And that's really how it's done. Okay. Now, should we talk only with Chinese officials? Should we talk with academe or local people? Well, all of that is still available. No, I mean, of course, you can do that. But at the end of the day, the question will be who has the power or authority to make decisions that can bind the states to any particular agreement. That has to be clear. If you're undertaking discussions between academics, it should be clear that those are academic discussions and will not be taken as expressions of official positions. And a lot can be done through those informal, non-binding talks. And hopefully, they can contribute to a better understanding between the two countries so that when they do meet officially at the formal level, they can have a much better discussion. Okay? But what is important there is that there must be close coordination of these discussions. No? Meaning you don't end up with a situation where, for example, your informal talks are actually undermining the formal ones, no? Or you're actually giving away stuff that should not be discussed at the formal talks. There has to be that clear coordination and delineation of what
your scope of work is and what your topics of discussion and what is the extent to which you can make commitments or statements at each level. That has to always be very clear and very well coordinated. Okay. On the second question, how do we approach China? What creative solutions can we have? Of course, creativity. I mean, I don't have a monopoly in creativity, but and in this case, more heads are better than one. No? But we have made suggestions before. What is happening right now is that China is asserting itself, trying to create a de facto situation in the South China Sea, trying to establish a de facto control and administration of areas in the South China Sea slowly, incrementally, so that eventually the smaller Southeast Asian countries will give up voluntarily, either by acquiescing or simply staying silent and just allowing China to do it what it wants, no? Or yeah, expressly even giving it up, no, through some compromise agreement of some kind. Okay, so to approach this, the way to combat this in a way is to not allow that de facto situation to become de jure, to not allow it to become legal, to not allow it to become the reality of the South China Sea. All of the countries must still insist on the proper application of UNCLOS, the proper recognition and exercise of their respective rights. That's why you have other countries like Vietnam or Malaysia or Indonesia always insisting and taking action to assert their respective rights, even if it might be symbolic, even if it might result in casualties. It is important for them to do so because that is how they see themselves as maintaining their rights and interests, protecting their interests against such a powerful neighbor. Okay, and the creativity there is seen in many ways. No, with Vietnam, for example, they used social media. They would use their strategic partnerships. They would balance off their relations with Russia against their relations with China. And there are many ways to do that. Okay, trying to, in a way, trying to make use of all available means to prevent themselves from being led into a situation where they cannot do anything, where they have no options. No, yung wala na silang magagawa. That is what we need to avoid always, no? Being led into that kind of a situation. That's why whenever the president says, wala na tayong magagawa, gigirahin lang tayo, I think that is the worst thing that you can do and say. You will never hear that from any of these other Southeast Asian countries. Okay? Creative solutions, some solutions that have been proposed but have not been taken up are things like talking with China, or instead of ASEAN China on an ASEAN China setting, something like an ASEAN minus in China. So especially with respect to discussions about the COC, for example, there have been proposals maybe arising out of the frustration with the slowness of the ASEAN process to just do the negotiations with only the claimant countries, and not involve the whole of ASEAN. Other possible creative solutions would be to have bilateral coordination with Southeast Asians vis-a-vis China, so that whoever China talks with in their bilateral discussions will still be faced with the same response to the same situation. Other possibilities can now depend on other creative solutions will now depend on the problem that it's presented. Okay, so like in the case of the maritime militia, for example, this action of revealing their presence and showing the world what they're doing is a creative solution, because that's precisely the way to address the maritime militia. The maritime militia has been successful all this time because their actions have never been seen as such. They've never really been portrayed as such, and that's why they get away with things. They're able to achieve their objectives, no, without being presented as militia, without being understood as a part of these so-called gray zone operations. And so those are examples that I think we can look at, no? And use them at different levels, whether it's in order to address a specific incident like what happened at Julian Felipe Reef, or at the broader level of negotiations with China over the South China Sea, we should try to explore all of these many different possible creative solutions and not limit ourselves to simply either talking or going to war. That is the most unimaginative and uncreative solution that I will ever hear.
Okay. Jay, okay. Patricia, I may add something just to clarify. This is Mrs. Del Rosario. Is it okay?
Yes, ma'am. Yes, ma'am.
Okay. We, as diplomats, we don't have a carte blanche to negotiate, especially on sensitive issues like this. When it comes to sensitive issues, we are given an authority to negotiate. And so a special group is chosen, and that group, as Jay said, they're composed of people with different disciplines, including marine scientists. But I also want to say that during the previous administrations, our relationships or discussions with China were not taken only bilaterally. We had to take them within a plurilateral or multilateral setting. In fact, what China wanted was to remove the multiple parties negotiation that Jay talked about, like ASEAN minus, because China wanted a one-on-one, knowing that if it's a one-on-one, it's bigger, and therefore the other one would easily cave in. And I think that's what we should avoid. We should go back to the, to the claimants group, discussing together with China. Yun lang. Thank you. And we did it. And then China tried to divide us. Okay, but it succeeded to a certain extent because Cambodia, Laos, and Myanmar were in the group. It was a whole ASEAN. So somehow they put in their own chairmanship in ASEAN to create a division in ASEAN. That's the part. That's the confusion there. Thank you.
Thank you, ma'am. And thank you, Sir Jay.
Okay, thank you so much, Professor J. Batongbacal and former Ambassador Lula Del Rosario for enlightening us on those particular issues. So now we will proceed with the open forum. For our questions from those from the participants who registered. So we consolidated the questions that are of similar topic. For unorderly proceedings, we will address those questions first, and then the questions posted in the chat box. This is to accommodate as many questions as possible despite our limited time. For our first set of questions, sir, a number of participants asks, how can the Philippines enforce the arbitral award? In relation to this, sir, there are 3 of the participants raised the following issues. From Dr. Carlos Tabunda Jr., how can we impress upon this government its legal obligations on the issue, and what can we actually do to force it to recognize its obligation? Another relevant question is from Professor Romel Banlawi. What are the activities in the West Philippine Sea by foreign entities that can be considered legal? And the next question, sir, what are the sanctions that we can impose against China, and how can regional cooperation be utilized to address the issue? This is from Mr. Eduardo Oban Jr. And lastly, from Mr. Ferdinand Buscato, he asks about the Philippines' relation in what are the Philippine interests in relation to the defense of the Julian Felipe Reef?
Okay.
Sir?
Yes. Okay. Okay. First question, how to enforce the award. I tried to answer that as well in the presentation. No? As I mentioned, no, there is no third party enforcer, and therefore enforcement of the award relies upon the consistency and persistence of the Philippines in seeking compliance. Okay, and in order to do so, no, that means conducting relations, conducting diplomatic negotiations. But as I mentioned, no, It doesn't have to be negotiations or relations on the basis of weakness. It should be relations on the basis of strengths. And the Philippines should leverage its strengths, no, such as the law, the fact that the international community supports our position, the fact that the international community recognizes our rights to the living and non-living resources in the West Philippine Sea, no, in conducting our relations with China. No? Persistence, and let me just tell you, enforcement is not an instant thing. No? You can only do this, especially in this context, it can only happen through a long process, no? of diplomatic engagement. Okay. How to impress on the government the legal issues? I think the government has quite a number of people. They have quite a number of people who are aware of the complex legal aspects of this issue, and they're always actually very careful, no, about them. But of course, naturally, you cannot expect these people to be out in the public, given that they have their positions in government and they might be seen as talking on behalf of government. So the best way, as I see it, that they've been doing this is through quiet discussions and consultations internally as well as with external people, specialists, observers, experts, even academics, people who study these or have experience in these. They're often consulting, especially in relation to a specific problem or issue. No, I guess the problem really is that that's well and good for the bureaucracy, the mid-level and the career people. But I guess our problem really is with respect to political appointees and people higher up, including elected officials. Some people simply they appear to simply not care at all about these things, unfortunately. And so the hope is that at least the professional bureaucracy would still be able to do its job at least. No? And I think for the most part they've been doing a good job. No? Especially if you were, especially if you look at the nitty-gritty. At least the professional bureaucracy, mid-level and career, they have been trying very hard to watch out for the Philippines' interests. Now, what activities in the West Philippine Sea can be considered legal? Well, as I mentioned earlier in the presentation, as a general rule, as long as those activities do not undermine our rights and jurisdiction over our living and non-living resources, nor will, as long as they do not contravene our jurisdictions, like on MSR, etc., in the West Philippine Sea, then they are permitted. Okay, but note that also that all user states must give due regard to the rights of the coastal state, no, with respect to all of these rights and jurisdictions. Okay. What sanctions can be imposed on China? Okay. Imposition of sanctions is not a simple matter of calling for other countries to punish another country. Okay. When you consider sanctions, it must be in relation to a particular area, a particular subject, no? And a particular or a particular problem. So, for example, when you talk about China's illegal fishing activities, particularly its continuing extraction of giant clams in the West Philippine Sea, which result in the destruction of our coral reefs. Okay. Those activities are illegal even in China. Okay, they have a law against that. And yet their fishermen go to Scarborough Shoal in the full view of the China Coast Guard and conduct these activities. And they make tons of money out of it. Okay. And the video of that particular incident in 2019 is even very clear. No? The
China Coast Guard even converses with these fishermen, probably coordinates with them, no, while they're conducting these illegal fishing activities. Okay, now in that case, it would be possible to get China to account for these activities in various fora. For example, the meeting of parties for the Conservation and Biodiversity Convention on Biodiversity. Okay, there's an annual meeting of parties, and there is a mechanism there that calls countries to account by asking them to report on their efforts in conservation and protection of the environment. And it is possible to make use of that to get China to report on what are they doing with these people who continue to conduct environmentally destructive activities, and what should they do to stop it. Okay? And the fact that you're able to call countries into account for that, no, normally gets them to respond, no, and take action. Another option is to have China brought. You bring up China, whether it's CBD or say international organizations like the EU, and have them declared to be state sponsors of illegal, unregulated, and unreported fishing. Why? Because the China Coast Guard is protecting their illegal fishermen. Okay? And if that happens, you look at what are the available sanctions for those activities. In the case of the EU, the ultimate sanction is to stop trading in fisheries with China. No, they threatened us with that actually when back in 2013 they said that we appeared to be not taking action against IUU fishing. Okay, so that's another possible option, possible sanction. Okay, there are many different kinds of sanctions. No, this is not just economic sanctions. Depending on what particular body of law you will be able to use and what particular venue or forum you will be making the call for accountability at. No? In the case of, well, to give an example, when we took a look about what can be done legally about China's clam digging on Scarborough, if I remember correctly, we had at least 7 different possible legal mechanisms to use to try to get China to act on it and try to, which could result in the stoppage, the withdrawal of those fishermen from Scarborough. Okay, some of them more like investigatorial mechanisms or inquisitorial mechanisms. Others slightly, and others all the way up to adversarial mechanisms, meaning another case. So those are all still available options. Okay, and it is up to the government. It was up to the government to choose which ones they would resort to, and that spans a whole range from bilateral negotiations all the way out to third-party arbitration again. So they're always there. You just need to look and you need to produce the options. And that's why I say, you should never allow the country to be led in the situation where it has no options. That would be defeat. And then lastly, Philippine interest in relation to defense of Julian Felipe Reef. Well, as I mentioned kanina, Julian Felipe Reef appears to be number one based on the assessment of government. It was possibly going to be the subject of occupation, a new form of occupation, and that was prevented by the dispersal. If that happened, then we would have, of course, another, essentially we would lose another portion of that area to China. And then the other issue was with respect to the fishing, no? They were using it essentially as a base from which to conduct fishing in the Philippine EEZ. Okay. So our interest in the West Philippine Sea, when you look at it, primarily has always been about resources, fisheries, and oil and gas. And then second to that would be security, national security, traditional military strategic security. And so I think that both of those interests were involved in the actions taken by the Philippines against the massing of those vessels in Julian Felipe Reef. Okay.
Thank you very much, Professor J. The second set of questions, sir, is relevant to the U.S.-Philippine relations, particularly the U.S. security guarantees in case escalation happens. In particular, Mr. J.J. Javines asks, how can the Philippines be assured of the U.S. support in reference to the MDT? There were doubts as to the provision of the MDT, which states that support of the U.S. will still pass through the approval of Congress. Do you think we are remiss by not letting the U.S. continue with their bases in the Philippines? Despite the good intentions for us to be self-reliant in terms of defense, this did not actually happen. And then another relevant question is from Ms. E.G. Dizon. Does the Philippines have any course of action that does not include relying on foreign powers? Another relevant question, sir, is from Mr. Dominique John Ramos. The United States is slowly losing its strength in global leadership. On the other hand, the People's Republic of China is gaining ground in world dominance. Now, the Republic of the Philippines is caught between these two opposing forces. Which do you think will be more beneficial for the future of our country in terms of pursuing an independent foreign policy?
Okay. Teka lang, I'm trying to write it all
Yes,
down. So
take your time, sir. Thank you, sir.
Okay. Okay, sige. Okay. With respect to the alliance, okay, how can the Philippines be assured of U.S. support in relation to the MDT? Now, okay. Philippine-U.S. relations and alliance relations have always been a particular problem for the Philippines, especially since the Philippines has always doubted it. And that, I think, is the root of the problem. You're the alliance partner, and yet you're not fully committed to it because you yourself are the one raising doubts as to its relevance and effectiveness. Okay? To the extent that you yourself are the one undermining the credibility of the alliance, no? By saying by statements such as, "Oh, the U.S. will never help us anyway, because the U.S. will not care, or they'll go to Congress first." I think that is the fundamental problem here. No? Alliance relations are give and take. Alliance relations are about converging in mutual interests. And just because you're allies does not mean that you can have differences or that your interests will not converge in other areas. Okay? Alliances are, in a way, also very practical instruments to enable states, the allies, to work together on issues and matters of common concern. It's not an agreement for somebody else to fight your wars for you. Okay? Let's get that clear. When it comes to the aid and support that is available to the Philippines as an alliance partner, no, it's not only with respect to going to war, it's also with respect to responding to situations that where your military forces are involved, no, and which could possibly escalate into an armed conflict. No? And the thing that most people do not understand is that when you talk about these requirements about, say, passing through Congress, that is with respect to the aspect of the alliance relationship where countries, the allied partners, will actually go to war, a full-blown war, full-blown armed conflict. It does not necessarily apply to situations less than full-blown armed conflict, or World War III, less than World War II. The security partnership is much more complicated, multifaceted than that. No? And that's why in the course of the last several decades, Philippines and the US have been able to use the mechanisms of the MDT, the VFA, the MLSA, and, well, intended to use also the EDCA. They've been able to use that alliance relationship, no, to provide assistance for situations less than involvement in a regional armed conflict or a war. Best example, Marawi. Okay. When the Marawi situation broke out, okay, what did the United States do? Okay, based on this alliance relationship, the United States was immediately able to provide pivotal reconnaissance support, ISR, no? So that they were able to even find where these the IS insurgents were, no? And they were able to keep track of them. No? The AFE was able to benefit from information, surveillance, and reconnaissance that was not in its inventory, so to speak, no? Because we didn't have those kinds of aerial assets, no? But they were provided that assistance, no, immediately, no? And the Australians, for example, which are our strategic partners, also came in to provide additional quick training support in urban warfare, if I'm not mistaken, no? As well as additional reconnaissance support, no? Which was pivotal for the prosecution of the effort against the IS insurgents. That is a kind of activity that is possible because of this alliance relationship. If I'm not mistaken, we were even able to withdraw some ask for additional ordinance because the AFP quickly ran through its inventory, no? And we asked for some additional ones, no? To use in that conflict. That is an example of how this alliance relationship can work even in situations less than war. So if you're talking about the South China Sea and an incident arises where a Philippine ship or aircraft is threatened, no? Guns pointed at it or missiles pointed at it, or it's actually shot at, or it is involved in a skirmish, no? Then the alliance relationship, no, kicks in. We can actually call on any available U.S. units to provide assistance in order to address that situation. It doesn't necessarily mean directly going to war, because even in any situation like that, you don't just push a button and all ICBMs will be launching. No? That's a childish move. No, that's not a mature appreciation of how situations actually are handled by countries. No? It's not as easy to go to war as people might think. No? And that's why these aspects of the alliance relationship have to be understood better. No? Have we been remiss in this? Well, I would say yes, in the sense that we're always the ones raising the doubts. And the United States has always had to keep on making statements, like the latest ones by Pompeo and the ones reiterated by Blinken, about the U.S. commitment to render assistance to Philippine troops, ships, or aircraft that are under attack in the South China Sea. How much more assurance do you want, in a way, no? Siyempre, that can only be tested when the incident takes place, no? But if you yourself have doubts and you yourself basically undermine that commitment by essentially not believing it, then don't expect the other party to give more, because what else can they say? No? What else can they say? Now, does the Philippines have a course of action that does not rely on foreign powers? So yes, of course. You know, most people don't realize it, but we have actually been rather independent way before this administration, and that has actually caused quite a lot of head scratching as well. No, to give you an example, during the Vietnam War, the Philippines was expected by the U.S. to provide additional support by sending troops to Vietnam. We did not. Okay, and that was a problem for them because they thought they had a commitment. Well, we didn't comply with the commitment. Why? Because we were also looking at other aspects of our relations, and we were basically independent, no, in our foreign policy. If you look at the record of voting in the United Nations, we do not always vote in lock in step with US votes. And we have differences with the US that our diplomats have also had to address. So with respect to the South China Sea, the same thing. We have recourses that do not rely on foreign powers. We have our own individual options as a lone country. We have options together with partners as well as other foreign powers, whether you call them middle powers or small powers or great powers. We have options. The key there is to be able to generate them when needed and pursue them in a coordinated and consistent manner. Coordinated and consistent with our long-term national interest. Okay. Now, with respect to the U.S. receding, China gaining ground, I think thinking that we have to choose between the two is a false choice. Okay. Choosing one or the other is exactly the situation. Is already the situation where you are foreclosing options and autonomy to decide. You're limiting your ability to generate options for yourselves. Okay? So it's not, again, it's not a matter of kakampi ka sa isa or sa kabila. It's not a simple case of just, taking sides. No? You have to understand that each one of those sides have their own respective interests that they're watching out for, and those interests will never fully converge with yours. Whether it's China, whether it's US, there will never all be a full convergence of interest so that you're essentially going to take one side or the other. We have our own side. We have our own side. The thing is to be able to see where, number one, which country do you have kumbaga, more aligned interests in a way, no? And work together with those countries on where those interests are aligned, no? Economic or military, whatever, you have to identify it clearly. And in cases where they converge, where they diverge naman, no, yung kabaligtad, yung talaga nag-clash kayo, then you see whether you have the option of either trying to compensate for it through the other, or compensate for it by seeking options beyond, outside of those two, meaning other powers, like the middle powers. Doesn't have to be always choosing between Japan or China. US and China. No? And if you're talking about the world, China gaining ground in dominating the world, well, what are you going to do about it? Are you just going to accept it by taking sides? Or are you going to try to work on making sure that that dominance does not result in you becoming a subordinate to this great power and essentially losing your autonomy, your sovereignty because of that? So it's a lot more complicated than just choosing sides. Yeah.
Okay. Thank you very much, Professor J. Batongbacal, for your explanation. The next set of questions pertains to China's maritime ambitions in the South China Sea and to Philippine-China relations. Ms. Dalisay Valles asks, China has, without a doubt, continuously disregarded international law. Albeit there are laws and agreements set in place, is there an actual measure we can take to hold China accountable and end their transgressions? Another question is, what is the main objective of China in its incursions in Philippine waters? This is from Mr. Anthony Kabilitazan. Another question, sir, is from Mr. James Eltanal. What is the plan of China with the Julian Felipe Reef? Will they develop it like the other three major man-made islands? And then, sir, another important question is, since the CCP did an infringement in our law and sovereignty, what is the best possible way in dealing with this issue? There is also a question. China has a very well-coordinated strategy when it comes to the West Philippine Sea, using the DIME approach, or the diplomatic, informational, military, and economic. The move of the military is always supported by diplomatic, for instance, coercion, information, for instance, propaganda, and then economic coercion. How can the Philippines deal with China's strategy in the South China Sea? That's all for the China question, sir. Oh, so there is another one. Sorry. Does China's vaccine donation have something to do with their intrusion in the Philippine EEZ? Did China seize their way to the Philippine territories through their Sinovac COVID-19 vaccine facade? This is from Francesca Zhao.
Okay. Sige. Sige. Now hindi ko mabasa yung sulat ko. Okay. Actual measures to make China accountable for transgressions of international law. Okay. This is not an easy question because international law is not one single thing. Okay. There's no single body of international law. And the transgression that you speak of has to be very specific, no? And making China accountable actually is a little bit vague, but let's put it this way na lang. When it comes to the West Philippine Sea and its continued activities in the South China Sea and West Philippine Sea, no, which in a way show how it is not playing by the rules. Okay, the way to make China accountable is basically, number one, to reveal those transgressions. Okay, and make sure that everyone is aware of what's happening. Okay, that's why, downplaying an event, hiding it sometimes, that doesn't work to our advantage, no, because that in a way condones that particular activity or action, and before you know it, they'll keep on repeating it, meaning and that leads you to even a bigger problem than before. Okay, when things happen that constitute violations of our rights in the West Philippine Sea, of violence of our living resource rights to the living resources, non-living resources, we should call it out. Okay, issue the appropriate diplomatic protest and conduct our relations on the basis of getting them to, number one, acknowledge that action, take responsibility for that action, and provide the solution, which is to either stop it or take an action that is in accord with our demand, such as withdraw your ships, diba? That is how to make them accountable. And by establishing a record of that, then, well, the idea is that if everybody knows how China behaves, then that will also affect the way they relate with other countries. And if China is smart and wants to avoid more problems and troubles, then it should then instead take the path of acting in accordance with international law. Okay, so again, depending now on the incident, like what I talked about earlier, the giant clam harvesting, the illegal fishing, there are specific ways of making them accountable for that in different fora. Okay, so that's why it's a little bit difficult to answer this question. I say there's so many possible permutations. Okay, what is the objective in its movement into Philippine waters? As I mentioned earlier, it's basically to establish de facto control and administration of the entire area that they claim. Originally described by the 9-dash line. Nowadays, possibly there might be a slight change in how they describe it, but ultimately they just want to establish that, de facto control administration of that entire area, get the smaller countries like the Philippines to recognize their claimed rights to that area, and to essentially, allow China to have its way in these areas. That's the objective of these incursions. What is Chinese plan for JFR? Will it turn into an artificial island? At best, from my own perspective lang, and I'm not talking for anyone here, no, but from my own perspective, the idea behind making it an anchorage is, as I mentioned, to establish a continuing presence, which can then be the basis for establishing control later on. Okay, will it turn into an artificial island? At this point, probably not, because we have not seen evidence of, say, dredgers going to that area, no? But who knows, maybe in a few years that might be possible if it makes sense to them. No? Okay, what makes sense to them? Of course, that's their call, and I wouldn't hazard a guess as to what would make them decide to turn it into an island. No, but of course, they've already demonstrated that they can do it if they wanted. So that can always be an option for any of these other unoccupied features. Okay. Doesn't have to happen now, and right now it's probably not going to happen because we're observing very closely anyway. Okay. Hindi ko na mabasa yung tulad ko. What is the way to deal with it? How do we deal with this? Okay. The way to deal with China's incursions and activities, basically, well, is the way that we've always been actually advocating, to always stand firm on our rights in accordance with international law, to always stand by the arbitration and call upon China to abide by it, even if she won't, but to keep at it, and to call on the international community, whether it's within ASEAN or with external powers, for support in our positions vis-a-vis China on these issues, so that when we do begin talking with them, we know that we have a stronger hand. We have diplomatic and political leverage still. Now, on the how to deal with the strategy in the South China Sea, well, as I mentioned, the strategy is to establish de facto control and administration. So the counter strategy is to not allow them to do so. Never recognize that de facto, do not allow that de facto control and administration to mature into de jure control and administration. Always insist on international law in our rights in accordance with international law in the arbitration. And then lastly, the vaccination. Quite frankly, I don't think it was necessarily connected. It might have been coincidental because the schedule for these vaccines anyway would have been set even before. I don't necessarily see a direct connection between the two. Okay, but definitely, I'm sure it factored into the discussions when they tried to talk with the Chinese side on this, because it's a real problem that here you are giving vaccines and yet they're complaining about you. On the other hand, on our part, it's also a problem for us because we thought we were on good terms, and yet you're sending your ships there, not doing something. So I'm sure it came up, but I don't think it was a deliberate. There's any deliberate and clear connection. Yan. Sige. Teka lang, sasaksak ko lang yung computer. Okay. Regular programming.
Okay, thank you very much, sir. Some of the questions submitted by the participants when they registered were already addressed by Professor Batongbacal in his presentation. So now we will move on the questions in the chat box. It is now 4:30, and we will select the questions that are directly relevant to the topic. To our topic for today. So from Mr. Zaimar Bandola, last year, ASEAN and China announced that the negotiations in the Code of Conduct in the South China Sea will resume. From your perspective as an academician, What is your view on this, and where do you think the Philippine government should stand on this COC? Would this be an effective mechanism to deter China's aggressive stance in the West Philippine Sea?
Okay, COC negotiations, of course, we've been observing that ever since we even started the initial negotiations for what became the 2002 DOC. Now, the thing here is that the COC, the concept of the COC came up back then based on certain assumptions. The most important assumption was basically that everyone was on equal footing with respect to the disputes in the South China Sea. At the time, everybody had small outposts in the middle of the ocean, and no one had any forces there that represented any kind of threat to anyone. And everyone was basically undertaking their respective resource activities on their side of the South China Sea, near their coastline, etc. That was 1990s. Now the situation is very different. You have one party that has established 3 large military bases and supported by 4 smaller islands with surveillance and jamming equipment, etc. Basically a military complex in the Spratlys. And they're far larger than anything that any of these other countries had ever seen before. And they're much more better armed. They're armed for more than just protecting the inhabitants of the island. And in terms of activities, you have China now undertaking resource extraction activities like fishing in the EEZs of the surrounding ASEAN states, okay? Reaching out beyond these disputed areas. And you have a situation now where clearly there is a huge disparity in power between all of these claimants. So it's no longer the same situation. So that's why that actually raises the question of whether or not a COC would still be relevant, given that it also raises the question of whether a COC at this time would instead of preserving a status quo or preserving equality between the parties so that they can reach a peaceful settlement, might instead result in the opposite, which is to create a situation of disparity and dominance, which prevents a equitable and peaceful settlement. So yeah, the very concept of the COC right now should actually be re-examined as far as I'm concerned. Nonetheless, since it's ongoing and it's evolving, as I see it right now, the COC can only be a means of addressing perhaps incidents and interactions between the different claimants at sea. That's the best thing that they can achieve with it, some way to ensure that their interactions at sea do not create situations that can easily escalate into a bigger problem or a bigger conflict, especially an armed conflict. So management of the disputes is the objective as far as I can tell. Whether that is possible given the disparities that I mentioned, now depends on whether the smaller claimants, the smaller states, and the ASEAN, who also include non-claimants, can actually get together and have a unified position on how best to handle the South China Sea disputes and keep it from interfering with ASEAN's other goals and objectives. Okay, so that's probably what we can sort of say about this. Whether it's effective or not, well, it's premature to say anything yet since they haven't even come up with the document. So hopefully it will be. Hopefully they will be committed to it, but we don't know until they actually have an agreement on it.
Okay, thank you, sir. There are relevant questions from Mr. Alfonso Directo. What are the lapses of the previous administration in the West Philippine Sea issue? During the standoff, Do you think China outsmart the US and the Philippines that led to their position in the Scarborough? In relation to this, sir, Mr. Austin of IDC asked, why did the US not help the Philippines when China took over the Scarborough or the Mischief Reef?
Okay. Previous administration in the WPS. Okay. Maybe the lapse was trusting China to keep to its agreement in its alleged agreement to withdraw. Okay. I think that given the situation there, the Philippines should not have withdrawn from Scarborough Shoal immediately. Should have maintained that standoff for as long as it can until both sides actually did withdraw. Okay. Do you think China outsmarted the US? Well, what else do you call indicating that you will agree and then not doing it? I guess yes. No. It's hard to deny that. You cannot deny that there was an attempt to intercede, but unfortunately, China didn't care much for the did not care much for the US essentially mediating. And so that's what happened. Okay? Why did the US not have, with respect to Mischief Reef and Scarborough Shoal? With respect to Mischief Reef, remember, Mischief Reef was a submerged feature. And China's incursion initially was on the argument that they were merely putting up fishermen's shelters. And it was not in any manner at the time something that could even be made out to be an act of aggression. That's how smart the move was. Okay? And because of that, there is no reason to call on anyone else, call on anything to help, other than to directly engage diplomatically with the country that created the problem. Okay? You don't call the Marines just with just anything. Okay. And in that situation at the time, 1995, when it happened, okay, the response of the Philippines was to engage with China in diplomatic negotiations. And it did again in 1999. And what did we get? China's assurances that these were only fishermen's shelters, China's assurances that it was only for civilian purposes, China's assurance that it was going to be open to joint use when conditions are ripe. Okay? Those were China's commitments and promises back then. Okay? So what can you do if they don't abide by their commitments? And that's years later. Okay? Scarborough Shoal, I guess the story of Scarborough Shoal, whether or not they helped, that is something that I do not have direct knowledge of, so I will not be able to answer this question. However, there are accounts elsewhere by other people. So like the persons involved would be, what's his name? Then Secretary Campbell, who's now back in State Department. You can ask Ambassador Fu Ying, who was the one he was talking with. And then you have the side already of the government, and it's already, I think, documented in, if I recall correctly, it's also documented in Marites Vitug's book. So I would refer you to that, for the answers to these questions.
Thank you, Professor J. Batongbacal. For our last question from George C., is the PCA a court? By normal definitions of law, aren't the agreements by parties to be mediated a requirement of any arbitration?
Aren't agreements by the parties? Again, aren't agreements by the parties?
Is the PCA a court? By normal definitions of law, aren't the agreements by parties to be mediated a requirement of any arbitration?
Okay, the question is perplexing. Okay, number one, permanent court arbitration is not a court in the same sense as a domestic court. Okay, and with respect to the South China Sea arbitration, as I keep saying that was decided by a tribunal. It's more appropriately referred to as an Annex 7 tribunal, which used the PCA as the registrar. Okay, that means that the PCA basically provided administrative support for the conduct of the proceedings. But the tribunal itself, its power, its jurisdiction flows not from the fact that it's the that it has PCA members or that it is housed in the PCA, but rather that from the fact that it is constituted in accordance with UNCLOS Annex 7 and Part 15. The power, the jurisdiction of the tribunal flows from UNCLOS as an international agreement to which both parties had signed, and both parties had ratified. Okay. So raising this issue whether or not the PCA is frankly irrelevant, to the fact that the tribunal was constituted and was duly empowered, granted jurisdiction in accordance with the terms in accordance with the provisions of UNCLOS. Okay. Normally mediated before going to arbitration, any agreement, the parties are mediated. I think what you're referring to is that in the cases where states go to arbitration, isn't there a requirement to first, in a sense, exhaust all remedies, which include prior consultation, prior negotiation, prior attempts to settle it bilaterally before going to a third-party arbitration or adjudication mechanism? Okay. Yes, that is normal. That is normally the sequence of events. You first try to settle it yourself. If you still can't settle it, then you go to a third-party dispute settlement mechanism. And that was actually done according to the tribunal, which, if you look at it carefully, actually does deal with this issue by showing all the steps that were taken by the Philippines and China from as early as the 1990s, going all the way up to 2012, when the standoff on over Scarborough happened. So those requirements, those steps were deemed to have been already taken by the parties, leading to no resolution. Okay? And because there's no resolution, recourse to arbitration was proper, and the Philippines properly invoked these third-party settlement mechanisms because it wasn't able to get a resolution after all those 17 years of negotiations, consultations, etc. Okay. So yun.
Okay, thank you very much, Professor Batongbacal, for clarifying that, and thank you so much for answering the numerous questions of all the participants. We have, when we started, we have around 299 participants. Now we still have 219, despite the fact that it is we are already beyond our schedule. So this means that the public has a very strong interest on this particular issue. So to formally conclude this event, I would like to call on Ms. Florence Principe Gamboa, Coordinator and Managing Editor of the Philippine Strategic Forum, for the closing remarks.
Thank you, Joanna, and good afternoon, everyone. Can you hear me?
Yes.
So on behalf of the organizers, I would like to begin by thanking everyone for attending and participating in today's webinar. Also, allow me to present this certificate of appreciation to Dr. J. Batongbacal for his invaluable contribution as a resource speaker in today's webinar titled China's Incursion in the Julian Felipe Reef, Legal and Security Aspects. The signed certificate will be sent privately. And for those who are requiring certificate of participation, kindly reach out to the organizers. Thank you again, Sir J, and thank you to Professor Severon for the enriching discussion as well. So I'm not going to pretend to be an expert on our maritime and international laws. The discussions this afternoon has been extremely rich and filled with complex information, vital in defending the Philippines' national interests in the South China Sea. First, we heard about the historical background of EEZs and UNCLOS, not only from Sergey, but from Ambassador Laura Del Rosario as well. The importance of this issue and for all claimants and not just for the Philippines. Then we heard about the particulars of the arbitration case filed and won by the Philippines, after which Sergey shed some light on what activities are allowed in the respective maritime zones and territorial seas. He then discussed the implications it had in the recent developments where a large number of Chinese maritime militia are in anchorage in the Whitsun Reef. Actions and policy recommendations were also stated. All of this, among other things, we heard as Dr. J and Professor Anna did such an excellent and extensive discussion. My key takeaway from these discussions is that we need to maintain constant vigilance over events and developments happening within our territorial waters. The need for vigilance is all the more needed in moments when we hear defeatist statements from our government and when misinformation and propaganda is rampant on social media. What we need are not statements that say we are inutile against foreign aggressors, but statements that remind them, us, and the world of internationally established and agreed upon laws, and that these are the very same laws that will keep the peace, stability, and security of the region. Finding diplomatic routes that strengthen our position and facilitate the exercise of our sovereignty and legally obtained rights, while at the same time foster cooperation and dialogue with other claimants and other major powers is the quintessential challenge of our time. And that is precisely the reason why we need more discussions like this. Platforms where experts like Dr. Batongbacal and other analysts, young or seasoned, can share their observations, analysis, and ideas that would contribute to the betterment of Philippine public and foreign policies. That is the goal of the Philippine Strategic Forum. So allow me also to take this opportunity to invite everyone to visit our website and social media pages, stratforumph.com, and contribute an article if you can. In parting, the pursuit of national interest must always be sought after through peaceful and cooperative means. If ever we find ourselves under economic and security pressures of a major foreign power, I would like to reiterate what Sergey also mentioned earlier. May we always remember the words of my mentor, the late Dr. Baviera, said that if one has to take a side, one must take the side of the Filipino people. That is all. Thank you everyone for joining us today and we look forward to having you with our future endeavors. Maraming salamat at